SJC-13410, Brian C. Carroll, and another, the Select Board of the Town of Norwell.
Okay.
Good morning. May it please the court.
Attorney Carroll.
Brian Carroll. Here is a pro se plaintiff. I'm also a member of the Massachusetts Bar. With me is Tim Wall, the other pro se plaintiff appellant. This case, Your Honors, presents a question this court has considered before. Where land is acquired by a town without restriction, when and how can that land become subject to a restriction on transferability pursuant to Chapter 40, Section 15A? On the facts of this case, the land court was wrong to determine that a restriction arose over the land at issue, which we've referred to as the wildcat land.
Before you get going, so is there a genuine issue of material fact at all? I mean, both sides agree on the facts, is that it?
So, Your Honor, there's two competing motions for summary judgment.
Right.
And two very different interpretations of the law around Section 15A.
But there are no questions about the facts?
There are.
Oh, there
For
are.
plaintiff's motion, under our interpretation of 15A, we believe there are no disputes of material fact. There were no disputes raised by defendants on plaintiff's motion for summary judgment. On defendant's motion for summary judgment, which is a very different interpretation of Section 15A, which looks at the intent of the town over a period of time, including sporadic actions of town committees over a 17-year period, and who thought what and who thought what when. We said to that, in response to that motion, there are disputed issues of material fact. We responded in the affidavits, we responded in the briefing, we responded in the pretrial statement, the initial case management conference statement, and at oral argument we raised the issue of discovery on defendant's motion. But what we told the court and the land court is, we believe our interpretation of the law of Section 15A is correct, and that is what should be applied. At oral argument, the court actually agreed on the transcript with that, and most of the oral argument was directed towards our interpretation of the law and whether mandamus would be appropriate. But if we're in a world where the court adopts defendant's interpretation of 15A, and a restriction can arise from something other than a written instrument, based on the intent of parties over time, then yes, there are disputes of fact that we do not have a
Can you
chance to take
just
discovery on.
crystallize for me on your affirmative motion? Where is the absence of the disputed material fact from your perspective? Is it that there's no deed restriction, or the fact that they never conveyed out this property to the folks or the entity that they created for affordable housing? What is the absence of it?
Yeah, so the facts pertinent to our interpretation of the law, the predicate facts, are identical to what they were in Selectman and the Town of Hanson versus Lindsay. There's a permissive town meeting article sometime in the past that doesn't impose any restriction. It just gives the board authorization to do something. The board elects not to do anything with that, and there's no dispute. The board has never taken any action over this land in the past 30 years related to that 2004 article. In fact, the only action the board has ever taken with respect to the land at issue in this case was to license the land to the neighboring open space residential development for the construction paths.
That's an oversimplification, right? They do a number of things. I mean,
The board itself has never done anything. That's undisputed.
Well, the town, the facts seem much more complicated than that. The town sort of authorized, well, I don't mean to cut you off.
No, not at all. Thank you.
I find it hard, particularly when neither of you discussed the Smith case, which is more open-ended than either the other two cases. So I'm just not sure how the town does a bunch of different things, right? First, it authorizes it for low-income housing, then it does some things pursuant to that, but then it rejects a low-income housing proposal. It just seems like we don't really know.
Right.
Yeah,
Right. But isn't it, again, that's why is it like 10 things and you say they didn't do all 10? Because they did do some things. I mean, so they had an analysis of wetland restrictions to see how much they could actually build on there and what it would support in terms of affordable housing. They did reject the offer of the neighboring developer. I understand that they gave a license for that path, but there were things that were done that were at least consistent with the idea that this parcel was still going to benefit affordable housing. You may not think they did enough, but there were still some things.
Your Honor, I don't think it's a quantum of activity question at all. I think it's a threshold question of activity. Did a use restriction apply to that land? Let me just walk
How
through
do you square that with Smith? Because Smith says, Smith seems to be employing a totality of circumstances test to see whether they've made a clear and unequivocal commitment to low-income housing, correct?
Smith that's correct, Your Honor. That's a very different type of restriction under Article 97 than we're talking about under 15A. And there's some very material differences between the policies underlying Article 97, which was adopted basically to codify the prior public use doctrine, which is the idea of that is to protect land that has been dedicated to public conservation, recreation use for all the Commonwealth, whether it be a road or something.
Don't they do the same type of analysis to determine whether that dedication has taken place?
No, Your Honor, not at all. I think that analysis in Smith is very unique to the public use doctrine, which has been in the common law for
Don't they
time
say
immemorial.
they're looking at common law sort of doctrines in Smith? Doesn't Chief Justice Gantz write that in Smith, that he's looking at common law doctrines, which are very similar to what we're talking about here?
I don't think they are very similar, Your Honor. I do think that what they're looking at in Smith is land dedicated to the public use. And when they say land dedicated to the public use, they mean land dedicated to the public of the Commonwealth. And they want to protect that land, and this is what the common law doctrine already protected this before 97, protected that land from the acts of local boards and local actors and local towns to say we want to take that away from the people of the Commonwealth. That's not Norwell's decision. Once it's been dedicated to the public of the Commonwealth, the general court now has authority over that land. And even under the common law, before Article 97, they'd say that Norwell held that land in trust for the people of the Commonwealth. And the question is, when does land become dedicated to the public good? And Judge Gantz says in that
Aren't we
case,
asking the same question? Whether the town has sufficiently dedicated this land to affordable housing. Dedicated is the wrong word, but whether the town has, made that commitment to public housing. And here they've done certain things, but not other things. They never transferred it to the housing commission, whatever the local thing responsible for low-income housing. They didn't do that, but at the same time, they do other things that are consistent with that.
But again, it's not a quantum of how much they did or didn't do. The question is there, I think the question under 15A is there a use restriction over that land? Could the board have used it for something else other than affordable housing? And the creation of a use restriction or a negative easement, again, is well established in the common law. You can have an implied easement.
Two conflicting decisions, right? We have Hansen in the other case, right? And
In Smith, you mean, or Harris?
we have three cases on point, right? We have Smith, Harris, and what's the other case? Lindsay? I can't remember.
Hansen versus Lindsay. Yeah.
So, and none of them are completely clear. Obviously, if you file a deed or if you transfer it to the relevant committee, that seems to be enough, right?
Yes, I think that the
Your
standard under
argument-
15A
I
is,
just want to make
did you
sure I
create
understand your argument. Your argument, right, is an objective one. Unless they do a deed or they transfer it to the right committee, they haven't done enough. Is that right?
I don't think that any of the case law specifically would be so prescriptive to say it has to be a deed or it has to be.
So what is enough?
But I think it has to be a use restriction under the common law, a negative easement that would restrict, that would actually be a land use restriction. If you look at section 15A.
What is that?
What creates?
What would be enough? Because I look at this and I can't tell whether they've done enough or are they not.
So there's three ways under Massachusetts law to create an easement. It's either an express easement, written in writing, in a deed, or in an ancillary document to the deed.
This isn't an easement case.
Right.
I would suggest, Your Honor, that the way 15A is written, it presumes that there's a restriction on the land. So 15A, unlike Article 97, is a transferability restriction. 15A doesn't actually say the town can't use the land for anything else. It says where land is already held for a specific purpose. That's the land that 15A applies to. That sort of presupposes that there's a use restriction. 15A doesn't say you can't use it for anything else. It says if there's a use restriction, here's the process you need to follow to transfer that land to another board. Article 97, by contrast, actually says where land is dedicated, you can't use it for any other purpose and you can't transfer it. So 15A is a different policy, or reflects a different policy. 15A is protecting continuity in local government. The town is the one imposing the use restriction, and they're imposing it for the benefit of the people of the town. And 15A says once the town has decided to do that and restrict itself, here's the process you
But
must
that's
follow
the-
in the future
but
to
we have to
remove that.
decide whether they've done enough to restrict themselves. And
Right. That's where I'm getting a little bit confused, because you're saying under 15A, you need something explicit. And I guess if you were looking, again, going back to Justice Kafker's view, and I'm not saying that the town prevails on summary judgment either. I'm just saying, if you were to presume that it's a totality of the circumstances view and say, the town's done nothing inconsistent since the time it said that this is for affordable housing. It's not like the Harris case where it was given for school and they came out and said, we want to do something else with it. The town has always said, this is for affordable housing. So although there wasn't anything explicit in terms of deed restrictions or easements or anything else that you can point to and say, look, well, I can understand that they might be accused of sitting on their hands and not actually executing on it, but they haven't done anything inconsistent with it.
Well, first, let me just quickly address the factual timeline here, because I think it is a little bit more simple. So the landhood was acquired without restriction. We all agree on that. In 2004, there was this permissive town meeting article. It said it authorizes the board to make available the land for affordable housing. There's no language in that article that suggests that anyone at that town meeting thought they were imposing a restriction on the land, or there's no language of exclusivity suggesting an exclusive use. They're authorizing the board to make available the land. And then nothing happens, right? The board says, okay, we could make available the land for affordable housing. It's still on the list of tax possessions of the town. It's still general purpose property. In 2009, they decide, they're talking to the developer who's doing the development nearby, the big conservation open space development, and that developer says we could build affordable housing on that land, and the board says, no, we reject that proposal. We want you to, as a condition to us approving your development, we want you to build trails on that land, tie it into the conservation corridor in Norwell. There's 100+ acres on the other
it's
side of
only
the
a
street.
sliver, right? They make sure they leave the guts of that available for a development, right?
Well, the license is revocable. They could always revoke the license,
But it's
yeah.
also only a tiny portion, right?
It's like a third of the lot. From where the path is on the lot, it would be impacted. So yeah, but the point is that all the possibilities were left open. The article was permissive. It says you can use it for affordable housing. Then the board never does anything.
Can I just take you back to the article?
Yeah.
The article, as I understand it, says it authorizes the board to make available certain parcels consisting of 3 acres, blah, blah, blah. Why is that not a specific dedication to this use?
Well, it's not a dedication to any use at all. It says they can.
That's just answer my question by
permissive.
stating it. Why?
Because it's permissive. It's not restricted
Well,
in any
what
way.
about this is permissive?
It says that they're authorized to make it available, but there's no language of restriction. No one at that meeting would have thought, we're restricting we're tying our hands as to this land in the future. Nobody would have thought that.
Your interpretation of that language is make it available or don't make it available.
Well, they can make it available. I would suggest that they could have made it available anyway. This doesn't authorize them to transfer the land. It doesn't authorize the board to impose a restriction on the land. This was passed as part of the consent agenda at the meeting without any discussion or debate. So nobody thought that this was in any way going to have long-term implications. My best guess, this would be speculation, is that the board was looking to say, we want to go out and talk to some developers and see whether this is possible, and we would like to have this to show the developers that this is real and we're thinking about this. But in no way was it a restriction on using the land for other purposes. Towns
So to be a restriction, it would have to say something like shall be.
No, I think that the
for-
way that this would work in practice is the town would authorize the board to dedicate the land for affordable housing, to restrict it, some language that indicates that everyone intends to, that the board has authority to put a use restriction on this land.
That would be like to make available only, is that,
Or to-
I'm just
to-
trying to figure out
to
what
restrict- I
words
think
need
that
to be
if
used.
they would say to restrict the land for affordable housing. But then, in order, under Hansen, even, in Hansen, the article at issue said the board is authorized to accept to prepare a deed and deed it to the Conservation Commission. Right, they had very specific authorization there.
But then they didn't do it.
And they didn't do it. Same in this case. The board never did it.
Well, here, they don't do that, but
The Community Housing Trust, which was formed years after the article, and in 2012 was then able to hold property. The Community Housing Trust, at some point after 2012, did some exploration of the land. They hired an engineer.
they hired
and a city
consultants in
manager.
2013.
But there's
to do
no
feasibility.
indication that was somehow sanctioned by the board or approved by the board. It's the executive is the board here, the selectmen, not the Community Housing Trust.
Really? I mean, the CHT isn't in existence until 2007.
Right.
So you couldn't just transfer it, you couldn't transfer the property to the CHT.
Until 2012, actually.
Right, okay, so 2012. Then 2013, they hire consultants. They are the town committee responsible for low-income housing, right?
That is correct.
And then they do a feasibility analysis for the unit to see if it's good for 40B.
They did site evaluation. They hired two consultants to do site
And then in
evaluation.
2019, they publish an update which identifies the Wildcat land as a housing development, right?
That's correct.
So it's like, there are a number of things happening here.
And this is why we disputed some of the factual conclusions based on those limited data points you said, because if we get into discovery and we put in the additional evidence, through all that time, while the land is identified in the housing plan, it's also identified on the tax treasurer's list of tax possessions as general corporate property. The land is also identified in the town's board-approved open space development plan as open space land in the town of Norwell, in this conservation corridor that is an important corridor for Norwell. So it's not, taking it in a vacuum, you could say, well, yeah, there were 4 acts over 17 years by the Community Housing Trust. But when you look at it all together, you say, there's nothing at the executive level that was a restriction. And I would just wind up by saying, I think that if we get into a situation where we're looking at totality of the circumstances to give rise to use restrictions, that's antithetical in a lot of ways to the Commonwealth's law about how restrictions on land use arise. And there's a lot of value in having towns have the continued flexibility over general corporate property. If they elect they want to explore one use but not restrict it, they should have the capability 20 years later when circumstances change to put land to different use. And that's what happened here with 2/3 of the town deciding that this land that has been trees and forest and wetlands for 30 years and has been recreationally licensed for 14 years should continue and maintain the status quo. That's what Norwell decided. And I think in the absence of restriction, they do have the freedom to do that.
Yeah, one question, Chief. Counsel, in opposing the town's motion, you just mentioned the issue about discovery. Did you oppose it on 56F grounds?
We did not specifically file a Rule 56F motion. We did not cite 56F specifically in our response. We did, and this is in the briefing, we did extensively object to the lack of discovery about the other explorations of uses of this land in town that we don't have access to. We did want to expedite the process, Your Honor, and we did want a ruling from the land court as to this threshold legal issue about 15A. We discussed it at oral arguments in the transcript. We did not expect that there would be a ruling in favor of defendants without the opportunity for discovery. So I do think we preserved that and asserted that very clearly at all stages, but we did not cite 56F expressly.
Thank you.
Thank you
Thank you,
very
Chief.
much. Okay, Attorney Galvin.
Good afternoon, Chief Justice, Associate Justice. May it please the court. Norwell was taken to the woodshed by the amicus in this particular case on its progress in affordable housing, but I don't think it was completely fair. This case represents Norwell's efforts to do precisely what the Commonwealth and the state has asked Norwell to do. In 2004, it went to town meeting. the selectmen were in possession of this general municipal purpose property, and it asked for the town meeting to decide whether or not this land should be made available for affordable housing, and it passed unanimously.
Made available, but then it doesn't,
Well,
then it's sort of getting the best of both worlds though, right? You've made available, so all that pressure to build low-income housing, you can say we're doing something, but you don't actually do very much. That's where I get caught up in whether you've done enough to dedicate this to a public purpose, or at least for summary judgment.
I understand why you would say that, Justice Kafka,
You
but
don't give it to that CHT or whatever it's called, right? You don't dedicate it.
True.
Transfer it to that, because if you transfer it to that, we're clearly in 15A, right?
I think if it was transferred, it would clearly be 15A.
So it's not transferred. It's also when someone actually proposes to build on it, you don't do it.
Well, that's because there's probably a quantitative difference between that which a developer would do on this property and that which the town would do. And in the record in this particular case, you'll recall the Community Housing Trust, there's an affidavit from a Greg McBride. Mr. McBride explains that they're working on a public housing project on this Wildcat land, and then they step aside because the police station is now abandoned. We have a brand new police station, and they focus on a public housing project on that property. And then they return to this property after they've got a feasibility studies done where they know they can construct 26 units of publicly constructed affordable housing, and that's what causes the attention of the abutters in this particular case.
Okay, but it just seems like the town is maintaining its ability to change its mind as it sees fit.
I disagree, Your Honor.
What binds you legally consistent with the three cases that are on point?
Well, I think it's pretty clear after Smith versus Westfield that you have to look at the totality of the circumstances. And I think it's been clear since Harris versus Wayland that you don't have to have a specific restriction on the property. And I think that was reaffirmed in Smith versus Westfield. I think the Hansen versus Lindsay case.
I agree with that, what you just said, but if we're doing a totality of the circumstances case, and we've got disputes on really what's going on in the town,
Well,
it sounds like we've got a factual fight
Well,
here.
Your Honor, I disagree for the following reasons.
Can I add one other obstacle for you? The Smith language is like clear and unequivocal, right? That seems like a tough thing to meet.
Well, that's only if you're applying the public dedication rationale. There's the
So you
prior
don't
public
think-
use
so-
issue.
So what is the test under your view? It's a totality of the circumstances test, but it doesn't need to be clear and unequivocal. It can be what?
No, I think, Your Honor, it has to be clear and unequivocal what was done. And remember, the land court's finding in this case that it was unambiguously the intention of the town to make this affordable housing. And to answer your question directly, if the town didn't intend to do anything in affordable housing, all it had to do was not act on this article.
Well, but isn't the question, and again, I don't mean to, it's a real question, it's not a rhetorical question. Is it clear and unequivocal that the town has dedicated this property to low-income housing? Right? You need, to win on summary judgment, right, you need that to be the case, is that right?
I believe that if you look at the plain intent of the language, and it's undisputed that the land was general municipal purpose property, all the town had to do if it wanted to preserve all of its options was to do nothing. But what it did is it affirmatively brought this to the voters, and they unanimously concluded that this land should be made available for affordable housing. And like in Harris.
But it didn't say only, and I think that that's what your opposing counsel is saying, is that the 2004 article is not clear enough to exclude other uses. And what's your response to that?
Well, Your Honor, it was general municipal purpose property. I don't think there's any dispute about that before the town meeting vote. And it didn't identify.
By identifying low-income housing, it's now exclusive.
Yes, Your Honor.
And what's your authority for that proposition? That is,
Well, again, I think it's pretty clear, statutory interpretation. We know what the land was available for before. We have this town meeting article, make the land available for affordable housing. I agree it doesn't say only, and I certainly could agree that it could have been drafted better. But, you know, we've had the circumstance in the Harris versus Whalen case where the town meeting article, which authorizes the purchase of land, said for school purpose. It didn't say only for school purposes. And then there was nothing ever done to transfer the land to the school department. But the SJC concluded in 1984 that that was specific enough, even if it was inartfully worded or not explicit enough to convey the general intent of the town. And I think what occurs in this case and why it's critical, beginning almost in 2009 or thereabouts, they hire a wetland scientist to delineate the wetlands. They hire a person to perform a 21E, green environmental.
But they don't transfer it to the CHT. They don't
Well,
put a deed restriction on it of any kind.
Well, deed restrictions with affordable housing are very different from deed restrictions with conservation land. The deed restriction, in order to be a perpetual deed restriction for conservation, has to be approved by the state. There's a whole review process, and then it's recorded.
You wouldn't file anything like that for low-income housing.
Absolutely not, Your Honor. The land becomes affordable in an apartment case when you sign a regulatory agreement with the Department of Housing and Community Development, now the Office of, I forgot the name of the division, it's recent change, or when you record a deed restriction in the case of a for-sale condominium unit, saying that this unit cannot be resold.
Do you have reporting obligations to that? I know we have 40B requirements. Do you have reporting requirements that you're satisfying by making things available?
Yes, well, there's a subsidized housing inventory maintained by the department. And
Was that somehow listed? Again, if it's in the record. Is there anywhere, I haven't read through this whole record, is there anywhere in
the
that
record, the only evidence of the town, we say its unmistakable intent was, we told the department in 2019 in our housing production plan that we intended to construct 26 units in phase 2, which was in the second year.
You filed that when?
We filed that in 2019 as an update to our housing production plan. And there are members of the select board that are on that.
And had you filed that document previously with the department, the State
It
Department?
gets updated, I believe, every 10 years, Your Honor.
So you do it once, and then, so was it done 10 years earlier?
It was, because it was an update to the housing production plan, and I know it's in the record, and the link was included in our record, and I think it was included in the amicus record, but
So in 2009, 2019, you made representations to the relevant state agency that this was in your inventory of low-income. What was the representation you made?
I can't say in 2009, Your Honor, but I can say in 2019, when the plan was updated, the town was very specific about what it intended to do on this particular property, because by that point, all of its pre-planning had been done, and we knew that the site could support about 26 units of public affordable housing. So when on the plan, it actually went in with a construction timeframe of the second year thereafter. So I think it was very clear. There was a large quantity of evidence in the record in this particular case about the town's efforts to study this property, to make sure that it was a...
So let me just ask another. So when Mr. Carroll and the others go in and try to convert this into Conservation Commission, do we have the record what was said? Does someone go up and say, no, this is dedicated to public housing, you can't do this? How does that work?
Well, this came...
Because again, totality of the circumstances, when this is presented to the town meeting, does someone stand up and say from the city, we've dedicated this to public housing? Does someone do that?
Yes, Your Honor, in this particular case. Well, first of all...
Is that in the record? Because again, that's what worries me, is that this record, and again, I haven't gone through all of it.
If you look at the affidavit of Peter Moran, who's the town administrator, this was discussed in advance of the town meeting. But remember how this article was presented?
In advance, does someone get up? Because again, I'm not familiar with how the town meetings go in Norwell. But does someone stand up in the town meeting from the town and say, we've dedicated this to public housing, so don't try to convert this into conservation land? Or does this just back into this with somebody saying, okay, we haven't satisfied, somebody brings it up at some point, but...
Well,
Because you would think you'd stand up and say, hey, this is public housing, right?
There are meeting minutes of the town meeting, and it was a very well-attended town meeting, and a lot of people spoke, and it probably had debate for over an hour, and
But I'm concerned, what did the town say? Did
it
the
is-
town stand up and say this is dedicated to public housing?
I'm sure that the issue came up, Your Honor, but I cannot honestly tell you what the moderator, who would be in charge of the meeting, may have said. But because this is
That suggests that this is premature and this requires a trial.
no, Your Honor, I don't think that's the case, because regardless of whether that was the
Because
case,
if it's clear and unequivocal that this is dedicated to public housing, wouldn't we expect someone to stand up in the town meeting and say, we've done this?
that's exactly what I recall, and I attended that town meeting. I know this isn't in the record, but there were a number of people that stood up and talked about the town meeting vote in 2004. And there were a number of people that talked about what had been done in the town ever since to study this land and how we were progressing towards a project on this site for affordable housing.
Does the city solicitor, I don't know, if you have a city solicitor, are you the?
I am the town council in Norwell.
So do you stand up in that meeting and say that this is
All-
again, based on what's in the record? I don't want you to recreate a record, but
The answer is, if I'm asked to, I do. I'm not always asked to. But remember, this is a citizen petition article. As long as they get the signatures, this goes on the warrant and we vote. And I've been at maybe 50, 60 town meetings over the last 30 years, and this happens on a regular basis, that people get enough signatures to do some things that do not comply with the law. And if I'm asked, I stand up and I say, look, this is of doubtful or dubious legality. I think that's the phraseology we use. I can't remember
again,
whether I
based on
did that.
this record, were you asked or not? Or is it
I
not in
was
the record?
asked before town meeting in this particular case, Your Honor,
Before it or at the town meeting?
before town meeting.
So, but that's not helpful. So no one asks and no one explains at the town meeting, at least based on this record?
On this record, I cannot say, Your Honor, one or the other. But what I can tell you is it came up before town meeting. And in the record is Attorney Moran's affidavit. He was the town administrator, where he recalls me discussing this with them. And then after the town meeting, not only did they look at my opinion, but in the administrative record is an opinion from Lauren Goldberg at KP Law. And her opinion is in the record, and she concurred with me that based on the totality of the circumstances and the 2004 vote and the things that occurred, this land was clearly set aside. And
Does the Smith case, I can't remember the date of the Smith case, are you aware of the Smith case at that point? It's a 2017. When's this vote? Yes, so Smith is old.
yeah, Smith was actually law 2017, Your Honor.
I got you.
I don't think that we mention it by name, but certainly everything about the town's position in this particular case is indicative of the Smith rationale. We think that there was an unambiguous intent to make this land available, and we've said that is designate the land for affordable housing back in 2004. Every conduct by the town, every action by the town and its community housing trust, which are appointed by the selectmen, by the way, are indicative of an intent to plan for an affordable housing project on this property. We told the state that they were going to do this. And then when we come forward with actual plans, it attracts the attention of the immediate next door neighbors. And, you know, they are not supporters of a affordable housing project on this site. And that's what triggers all of this. I think I'd like to make the point, even if the land were not restricted, whether the selectmen who have custody of this land are not obligated in a mandamus action to do anything. The legislative body is the town meeting. The legislative body cannot tell a coordinate branch of government how to perform a discretionary act. So I would say, regardless of any of those issues, which I think cut in favor of the town to begin with, even if they didn't, the town cannot be compelled, the selectmen cannot be compelled to perform a discretionary act. This isn't simple as counting the ballots, which you have an obligation to do correctly. This isn't the obligation to issue a building permit or deny a building permit when you haven't complied with explicit provisions of law. Those are the traditional mandamus cases. And I know Justice Smith didn't address the standing issue, but we raised it as a part of our appellate argument and gave a notice of appeal relating to it, because the plaintiffs in this case invoked the public right doctrine in order to excuse or relax the standing threshold. And
Won't they satisfy standing? I mean, they're butters, right?
Correct.
I take it their housing values are gonna be higher if it's conservation land. Isn't that
Your Honor,
a reasonable
this is not in the record, but I have been involved in development of affordable housing for as long as I've been a lawyer. And I've heard repeated expert testimony given in other circumstances that the construction of affordable housing next door to your
not even
property.
focused on affordable housing. Conservation land itself has, basically you've expanded your own property when you have a conservation land next to you because you have open space that no one can build on. So that tends to add value to your property, doesn't it?
I guess they could argue that, but I'm not sure that value to property is a cognizable interest when we're talking about affordable housing.
Doesn't that provide standing?
I don't think so under the Standardwick line of cases. You have to connect it to a legitimate zoning-related concern in order to gain standing. And, you know, all they've articulated in the record is that justice requires the court to intervene and direct these selectmen to convey this property. And I say that that's not, under the case law, enough to invoke the public rights doctrine. You still have to prove a modicum of standing, and just claiming a general justice issue is not sufficient to do that. And I cited the cases in my brief on this particular issue, the Mediri case and the Perella versus MBTA case. And when there is no clear and unequivocal duty to the public, there is no standing, even under the public right doctrine, to bring a mandamus action. And I know that Justice Smith had a lot in front of him, but I would certainly suggest that that was something that he probably should have examined as a threshold matter. The last thing I'd just like to say, Your Honors, is that at the case management conference, the issue of discovery came up, and both parties reported to the court we were prepared to proceed. I had already served my motion for summary judgment and the facts, and the statement by both parties was, we're ready to proceed. That issue came up at the time of summary judgment because I filed a motion to strike their affidavit because the objections that were raised to the evidence that the town submitted were not met with the appropriate countervailing materials, and that is in the record. Most of it was, well, that's information possessed by the town, and we don't know anything about it. Things like that. Those were not sufficient objections in order to defeat the town summary judgment. And I think, as the court pointed out, anytime someone files a Rule 56 affidavit, the court is obligated to look at it very differently, and there was an election not to do that. So for those reasons, I'd ask the court to affirm the decision of the land court and determine that the land must follow the 4015A process, which may very well likely result, if it's a popular decision in town, that's land being transferred to the Conservation Commission. But that's the process we think that should be followed in light of the totality of the circumstances.